What is equitable distribution, and how does it differ from community property in divorce? It's a good question, and there are many resources available online that explain the difference between equitable distribution and community property, but I like this article by Deborah H. from the Mississippi Law Journal entitled Equitable Distribution, Implementing the Marital Partnership Theory Through the Dual Classification System. This can be found in Volume 67 from the Fall 1997 series at page 115, specifically pages 130 to 133, and I'm quoting now. The primary difference between community property and equitable distribution is illustrated by returning to the example of Linda and Billy Ferguson. During their marriage, Billy's income was used to acquire and title assets in his name, while Linda's income was used for living expenses. In a community property state, Linda would have a vested 1/2 interest during the marriage in Billy's employment-related assets as well as his businesses. Consequently, her creditors might be able to reach 1/2 of Billy's business assets. In fact, Billy's ability to transfer and manage his business property would be affected by her interest. If Billy died while still married to Linda, his estate would consist of only 1/2 of the assets titled in his name. On the other hand, the result in a common law equitable distribution state would be exactly the opposite. Linda would have no vested interest in assets titled in Billy's name during the marriage. His ability to transfer, mortgage, and manage assets would be unaffected by equitable distribution. If Billy died during the marriage, his estate would include all property titled in his name. Any interest claimed by Linda at his death would flow from the state's spousal share provisions applicable under the title system. Therefore, in a common law state, Linda and Billy's property rights are governed generally by the title system. Only if they divorce will equitable distribution and the corresponding notion of marital property become operative. In dual classification states, i.e. states that have classes of marital and separate property, a court begins property division by classifying assets as marital or separate property. Marital property is generally defined as all property acquired by either spouse subsequent to the marriage, with certain stated exceptions. These separate property exceptions include assets acquired prior to marriage or traceable to premarital assets, assets acquired other than through marital partner efforts, such as gifts and inheritance, and assets designated as separate pursuant to agreement. The classification process is critical to accomplish the purposes of equitable distribution. It has been suggested that the dual classification system probably acknowledges most divorcing spouses' expectations about what is marital and what is separate. Without recognition of separate property, the notion that spousal property rights are based on marital efforts becomes meaningless.